Good afternoon, everybody. This is Bonnie Vandermeulen, Training Coordinator for Wisconsin Facets. On behalf of our entire Wisconsin Facet staff, I'd like to welcome you to our webinar this afternoon entitled Special Education During COVID-19, an Update. Our presenter for today's webinar is Jeff Spitzer-Resnick. Jeff is a nationally recognized attorney with over 34 years of experience in the fields of civil rights, disability, and education law. He is the principal at Systems Change Consulting, a consulting and training law firm providing local, statewide, and national consulting and training for individuals, nonprofits, and public entities. Systems Change Consulting focuses in making progressive systems change in the areas of civil rights, disability rights, general and special education, and combating abuse and neglect of vulnerable populations. It is my sincere and great appreciation in introducing you today, Jeff Spitzer-Resnick. Jeff?
Thanks, Bonnie, and welcome everyone. Just a few introductory comments. First of all, since we do have hundreds of you on the line, and many of you did submit questions in advance, we're going to do two things. One is many of those questions that were submitted in advance will be addressed simply during my presentation. Some of them may not be, and probably around 1 o'clock, I'll stop the formal presentation and I'll have Bonnie choose some of the questions that I didn't get to, or if those of you who want to put additional questions into the chat box do so, then we'll get to as many questions as we can. To respect everybody's time, however, we'll finish around 1:15 as the program was advertised. The other announcement I want to make before I get started is that the beginning of this presentation will not be specifically about COVID-19. It will be about basic special education law. Some of you may already know that, but especially in a group this large, I'm fairly certain that many of you won't know many of the things that I'm going to be talking about. And I do this because when we talk about what's different than normal, if you don't know what normal is, and by normal I mean normal special education law, then you won't really understand the differences. So for those of you who really do feel like you already know that, please bear with me, but it's important, I believe, to go through this. I would also want to give one caveat of what I'm not going to be doing. I'm not a teacher. I'm not a special educator. I'm not going to tell people how your children should be educated. I'm a lawyer. I believe I'm an expert in special education law, and I'm going to share that expertise with you. So for those of you who are looking, and I totally understand those of you want to know how on earth can you educate my child, I'll talk about the law around that, but I won't be able to say, well, your child should get this type of education. All right, let's move on. I will tell you this presentation software I use always takes a little bit when we were on one slide. There we go. Hold on. And now, of course, it went too far. All right. So first of all, what laws are we going to be talking about? We're going to be talking about the IDEA, which is the federal law, special education law, and Chapter 115 Wisconsin statutes, which is Wisconsin special education law. They're mostly the same, but not completely the same. And for those of you who have heard, oh, special education is just a federal mandate, well, here's a tidbit that you may not know. Wisconsin had special education law before Congress passed it. So it is not a federal mandate in Wisconsin. There is federal mandates, but Wisconsin came first. A little bit of vocabulary: free, appropriate public education. This is the most important concept in special education law. The acronym is known as FAPE. And not that long ago, a few years now, but in the law that's recent, the US Supreme Court case known as Andrew F. gave us a much better definition of FAPE than we used to work with. And you see that those quotes are exactly from the case. So your child's IEP, which you can see that's another acronym, Individualized Education Plan, or Individualized Education Program, must be reasonably calculated to enable a child to make appropriate progress in light of the child's circumstances. Now, the question is, what's appropriate progress? And for that, you look at the second bullet. Every child should have the chance to meet challenging objectives. Now, what's challenging for one child is not the same as what's challenging for another. Remember, this is all individualized, but it should nevertheless be challenging. Let's talk about some of the mechanics, because you don't get into special education unless you're evaluated, and anyone can refer a child who's suspected of having a disability. You, the parent, a teacher, a doctor, the principal, anybody can. Once it's done in writing, and I recommend if you do it, keep a copy for your records, you see the 60 plus 30 means that the evaluation must be completed. And the 60 days isn't exact. I'm going to tell you there's a little quirk in there. The quirk is that even if you submit the evaluation request, the 60 days doesn't start running until you sign one other form, which is a consent to evaluate. Now, I've often criticized this rule because if the parent submits the request for evaluation, then clearly they've also consented to the evaluation. But if not, let's say it was a teacher or a doctor, okay, fine, then I understand the consent. So if you submit the evaluation request, you should be pretty quickly, within a matter of days, getting back that consent, sign it and return it, and that's when the 60-day clock starts ticking. The plus 30 days is that the IEP team then has an additional 30 days to complete the child's IEP if the child is found eligible. Get to the next slide. And let's see if we skip. No, we didn't. Sorry. Okay, so at that initial IEP meeting, we want to make sure that everybody's there who's supposed to be, and this is legal. This isn't just an ought to. There are optional people, but there are 4 mandatory people. The LEA, what is that? LEA stands for Local Education Agency. In almost all circumstances, that is a fancy name for school district. The reason why we don't just say school district is because in a few exceptional circumstances, let's say the child is incarcerated or in a mental institution or something like that, then they may have something that's not a school district, for example, a state agency that's the LEA. And what I really should have typed out there is not just LEA, but the LEA representative. This is a really critical person, and that person can be a variety of people. In some smaller school districts, we actually will see a superintendent there. In larger school districts, it's usually somebody who's known as a case manager. And the point of that person is to, A, have knowledge of all the school district's resources that could be provided for the child, and B, have the authority to commit those resources. This was put in the law back in 2004, which is the most recent version of the IDEA, because what we used to have happen is the team would meet, discuss, and then somebody in the central office after the fact would say, oh, no, we can't do that. If that happens, it's completely illegal. And if during an IEP meeting, somebody in the IEP team says, oh, well, we have to check with downtown, or we have to check with the superintendent or whatever, somebody who's not at the meeting, then you as a parent should say, you know what, this meeting needs to stop. Because if the LEA doesn't have authority to commit resources, this meeting's not legal. And get someone here who has the authority to commit the school district's resources. Next, the special education teacher who should have recent training and knowledge of the suspected area of disability. Now, to clear up one point of confusion, because an increasingly high percentage of our special educators are certified under what's known as cross-categorical. So let's say your child has autism. Many people say, well, that means I have to have somebody who's certified to teach children with autism. That might be nice, but the law doesn't mandate it if, for example, a cross-categorical teacher has recent training and knowledge in autism. Regular education teacher is also required. There's only a very few situations where they would not be, and that would be if under the rare circumstance your child has such severe disabilities that he or she would never, ever be involved in any regular education, not art, not music, not gym, not even, let's say, general lunchroom situation. In that case, the regular education teacher would be excused. Now, one problem that sometimes arises here is, they'll pick the gym teacher, even though, let's say, the child's most critical need is in reading, and you'd really rather have the general educator for reading there. Unfortunately, you can make the request, but it's the school district that gets to decide which staff come to the IEP meeting. The parents, of course, one or both. The student, when transition age, and in Wisconsin, that's 14 or otherwise appropriate. You can bring a younger child, but the law doesn't mandate it and doesn't give them a right to be there before 14. And of course, they don't have to be there. We're now in an optional. If it's inappropriate to bring a child over 14, they don't need to be there, but they will be invited at 14 and up. And then, of course, in the other optional category, any other participants, whether it's from the school district or the parents, who have specialized knowledge of the child, such as private therapists, and that could be psychological, PT, OT, whatever. I've already mentioned the evaluation timeline, so we're not going to go over that. One other thing to keep in mind around evaluations is that if the child is determined to be eligible, two things you should be aware of. One, school districts must reevaluate every 3 years just to make sure we still understand the child and what their disability is. But it is also an eligibility determination, especially with young children, often with speech and language disabilities. They may literally be, it's not exactly grow out of the disability, but they may have gotten enough support as a young child that they may no longer be eligible. And that can happen. Parents or other staff can also request a reevaluation in less than 3 years. And that's important if, for example, something changes. So let's say the child is eligible because he's deaf, and then he's in a terrible car accident and now has a brain injury and really is in a very different situation than he was at the time of the last evaluation. That would be a very appropriate time to ask for a reevaluation and not wait for the 3-year time. Now, because Congress in 2004 didn't want, frankly, parents to hassle school districts too much, Congress said that if it's less than 1 year from the last reevaluation, the school district can say no. In general, that's going to be the end of it. However, if in, for example, the situation I just gave you, there's really been a significant change of circumstances, make sure you tell the school district that, because they now risk, if they don't reevaluate after that child had that car accident, they're not going to be able to deliver a free appropriate public education because they're going to be delivering an IEP that's not appropriate for the child. When you write the IEP, the most important starting place is the present level of performance. You can see its acronym is PLOP. It should be measurable. What do we mean by measurable? Saying something like the child should improve his reading is not measurable. We need to know how much. The child should improve his reading from 2nd grade level to 3rd grade level. That's measurable. The goals must be related to this. So if the child has a reading deficit, let's say we'll stick with reading. He's in 6th grade, he's reading at a 2nd grade level, then we have a goal about improving reading. And it must cover all areas of need. What's important here is that the goals are not limited to the area of eligibility. So for example, a child with autism who also has some speech and language issues, but maybe wouldn't qualify purely on speech and language, but because they qualified under autism, they still have a need in speech and language, there can and should be a goal there. The last bullet point I have, which isn't exactly in the law, but it's very important. Your child's IEP, and some of you are going to laugh about this because it doesn't often happen, should pass the stranger test. What does that mean? That means that I'm assuming I don't know any of your children, and if any one of you gave me your child's IEP, that I, if it was written properly, would be able to understand it, and if I were a teacher, to be able to implement it. And if you have an IEP for your child that is written so full of, I don't know, bureaucratic gobbledygook that even that you can't understand it, then it doesn't pass the stranger test. And my advocacy tip is at the IEP meeting, say, you know what, I don't understand what this is. We need to write something that I understand and that anybody else who reads this can understand. Come on. There we go. So I've mentioned that the goals and objectives must be measurable. One point about objectives. Back before 2004, for any of you who are old timers on the webinar like me, we had both goals and objectives. So for example, we'll stick with the reading one. If the goal is to improve the child from 2nd to 3rd grade within a year, and remember IEPs last 1 year, so that's what the goal time frame is, we might have objectives underneath that, which could include an objective around reading fluency. It could have an objective around how quickly, like in other words, is this a steady pace of improvement, or do we expect a slow start and then ramping up towards the end of the year? Now we only have to have objectives for the most severely disabled children who the team decides cannot take standardized tests. However, it doesn't mean you can't ask for them. And if the school district says no, one of the things we can do is build objectives into the goal. So for example, instead of a goal that is written that says the child shall improve his reading from 2nd grade level to 3rd grade level by the end of the year, it could say the child shall improve his reading from 2nd grade level to 3rd grade level at a consistently improving pace throughout the year. Now, what does that do for your child? That tells you that when you get a quarterly report, if your child hasn't made a quarter year of progress in that first year, then that goal is not being met. You don't have a consistent pace. And you may decide to ask for an IEP meeting and say, hey, what's going on here? Why isn't my child meeting this goal? The goals should address all areas of concern: academic, behavioral, social skills. And transition, by the way, is that transition to adulthood. Is it going to be for those students 14 and over, going to be going to college, working, daily living skills, that kind of thing. And by the way, it's not either or, okay? Lots of students who go to college also need work skills. Many school districts operate on a false dichotomy, a false split, where you either go down one track for transition, you're going to graduate high school and go to college, or you go down another track. You're going to maybe not even graduate high school and need social skills and adult living skills. Once you've written all those goals, we want to know what accommodations, services, or supports the child needs to meet those goals. That could be assistive technology, accommodations, therapy, and each one of those, including the amount of specific special education, should state an amount, a location, and a duration. So for example, let's take physical therapy. It should say something like, and again, this will vary by student, but something like 30 minutes per session, 3 times a week in the physical therapy room. And that way we know that this isn't happening in the general classroom. We know exactly how much it's supposed to be. And then if it doesn't happen that way, I like to think of IEPs as a contract. And if that means the school district wasn't meeting its contract. We also need to know where it's going to take place. Normally, that's what kind of classroom: special ed, regular ed, one-on-one. LRE, that's another acronym. it should be in the least restrictive environment appropriate for the child. The default is the general education classroom for that child. But of course, for some children, that's not appropriate, so we can get it more restrictive if necessary. And now that we're in COVID-19, of course, we've got a lot of virtual education going on. So anybody writing new IEPs, you're going to see that virtual quite a bit. Here we go. There's a few other IEP issues I want to touch on. Extended school year, ESY. Many of you may have discussed that for this summer. Some of you may have received it. It's usually a discussion that happens in the spring towards the end of the school year. And the basic concept is that look, all children regress somewhat educationally over the summer. But some children, not all, some children with disabilities will regress so much that it will take them so long to recoup that knowledge in the fall that you're like wasting, let's say, 3 months instead of, say, the normal 1 or 2 weeks that, teachers will review the last year's lessons before they really get going to new stuff. In which case, the child will need extended school year. That extended school year should focus on the child's needs that will be the concern of the IEP team that they will regress about. And I want to point out that this is not summer school. It doesn't mean that it can't and often does take place within a summer school environment. But for example, there may be some smaller school districts who will literally say things like, well, we don't have summer school here at our school district, because that, by the way, is optional for under state law. They don't have to have summer school. So we're not going to do ESY. That would be an illegal statement. School districts don't get out of ESY because they don't have summer school. Other things to touch on, students who have significant behavioral challenges will often need a functional behavioral analysis, an FBA, in order to determine what is the function of their behavior. Because if we don't understand the function, then we won't know how to provide appropriate supports. And they may need a behavior intervention plan. This is obviously not for all students. Some students with disabilities, many students with disabilities, have no need for behavioral interventions, but those that do ought to have a behavioral intervention plan. I think I mentioned assistive technology before, but this has become even more critical under COVID-19, since so much of our education is happening through computers. But keep in mind, it's not necessarily just a computer and software. It could be as simple as a pencil grip, those triangular things that for those who can't grip a pencil. So it's not always expensive, and it's not always involving computers. Let's go to the next slide as soon as my computer cooperates. There we go. Placement, I mentioned, least restrictive environment, so I'm not going to spend too much time with that. I've talked about goals. I'm going to try to move through this pretty quickly so we can get through the to the COVID stuff, which I know you're all waiting for. Keep in mind this piece. The IEP must describe how the child's progress towards meeting those annual goals will be measured and when those reports will be made. It cannot be less often than regular ed students get it. In other words, that would typically be quarterly with a report card, but it can be more often if your child particularly is struggling, and waiting 3 months or 2 months, whatever the quarter is, to find out how your child is doing on their goals may be too long. I've mentioned transition. One thing that I want to point out is that independent living skills can be part of that. Talked about who needs to be involved in the IEP team. One thing that I want to point out here is that people can be excused from an IEP team, but the parent has to authorize that. What I've witnessed, and many of you may have witnessed a lot, is that you start the meeting, and let's say the regular ed teacher can't be there for whatever reason. and you're just handed a piece of paper and told, we can't start this meeting until you sign it. Well, if you don't need that regular ed teacher there, fine, go ahead and sign it. But if you do, you can just say, you know what, this is really annoying. You should have told me beforehand and not wasted everybody's time, because I'm not having this meeting without the regular ed teacher. So, again, I'm not saying you should be a stick in the mud, so to speak. If you really don't need that person there, fine. But if you do, then you have a right to say, no, we're not having this meeting and I'm not signing this piece of paper. Even before COVID-19, you could agree with the district to have an alternative means of participation, such as video conference or conference call. Now, before COVID-19, that was typically just so, for example, let's say your child has a private therapist and they couldn't make it to the meeting, but they said, hey, I don't want being on a conference call for part of the meeting. I always say to parents, make sure the case manager knows that, so that they can have a good speakerphone or whatever technology you're going to use. Now, and I'll talk a little bit more about this later, almost all IEP meetings are happening via video conference, and the challenge is different. What if you as the parent don't feel comfortable with that? And I'll get to that a little more later. Let's get this slide to change. Come on. Oh, of course it went too far. There we go. Sorry. Now, this happened to probably almost every one of you, say around March, maybe April, depending on your school district of last year when schools were shut down. Now, normally, you can make a mid-year change. And by mid-year, I mean middle of the IEP year, since children have different timelines on their IEPs. The IEP year starts the date the IEP was finalized and ends 1 year later. Sometimes it's very reasonable. Let's say your child has, let's go back to the physical therapy example, 3 times a week, 30 minutes each time, but they've made so much progress. And the problem is, they've made so much progress that the physical therapist and the teacher have been talking, the physical therapist has been pulling your child out 3 times a week and they're missing some academics. So you could have a full IEP meeting to reduce the PT. Let's say the PT believes the child only needs it once a week now. Instead, the PT, maybe the special ed director, approach you and say, you know what, if you're okay with this, and we'll explain why, we'd like to reduce your child's PT to once a week. And rather than having an IEP meeting, if you'll just sign this form here, that's what we'll do. And if you're okay with that, great, sounds good, no problem. But if you're not okay with it, you can say, nope, sorry, we need an IEP meeting to discuss this. The problem during COVID is what we saw, particularly in March and April. Some school districts literally just sent a form called an I-10 and announced what the child's changes would be in their IEP. That was not legal. There were no legal, nothing legal about that. It cannot be unilateral from the school district. Oh, sorry. Now, what do you do if you have a problem? There are a variety of ways to deal with problems. And the 3 I have listed here, which I'll talk about in a moment, are all the formal ways. Before you get to any of them, of course, informally, talk to the teacher, talk to the principal, talk to the special ed director, see if you can resolve it informally. But if you can't, Wisconsin, like all states, has a mediation system. And all states, because the federal law requires it. We didn't have one before 2004 when federal law required it. Wisconsin's is very good and has a very high success rate. Over 90% of the cases that are mediated result in an agreement. The nice thing about mediation is it's all voluntary. The mediator cannot tell anybody, not you, not the school district, what you must do. They're not a judge. And they are very skilled at improving communication, and their goal is to see if they can get an agreement. The worst case scenario is you've wasted your time. Now, nobody likes to waste their time. I don't mean to make that lightly, but you won't be forced to do something you don't want to do. It's free to the parties. Now, if you have an attorney and you're paying your attorney, that's not covered, but the mediator costs nothing. And again, everything's voluntary from are you mediating, who's the mediator, where's it going to take place. Now, the where these days has been on Zoom, and I have to tell you, much to my pleasant surprise, I've already conducted as the attorney for clients 3 sessions of call it Zoom mediation. And they actually work quite well. For those of you who may not be familiar with the breakout room idea in Zoom, that's what's done in order that the, like let's say you're there with an attorney or an advocate, or maybe just you and your spouse, can talk privately with the mediator and not in front of the school district. As you would do in a normal mediation, you might break into 2 different physical rooms. So I was very pleased, and I wouldn't, you obviously have to have access to the technology for that to work. And I honestly don't know if parents don't have access to the technology, what the special ed mediation system is doing, but I would hope that they have some fixes for that. Another dispute resolution process is submitting what's known as an IDEA complaint to DPI. DPIs are in Wisconsin, our State Department of Public Instruction. You can complain if, for example, the timelines haven't been met or some other thing has gone wrong about your child's special education process. My personal recommendation, although you have the right to complain about anything to DPI, they have a form online, but you can also just send a letter, is I tend to reserve these complaints for what is very provable on paper alone. There will not be a hearing. If it's a judgment call about somebody did or said something and the other side says, no, they didn't, DPI isn't going to substantiate that complaint because they're not going to listen to witnesses and decide who's telling the truth. But if it's provable, for example, I've seen situations where, let's say the school district is consistently missing the 1-year renewal and revision of an IEP. Not by a day or 2, but it's taking them 2-3 months late. They can see that on paper. They can see the dates of the IEPs, and you're tired of it. Maybe you've got some fellow parents who are tired of it. You submit that complaint. DPI will substantiate that and will tell the district that they have to submit a corrective action plan that will not only address your concern individually, but will also stop the problem within the school district. Last but not least is due process. That's a hearing in front of a due process hearing officer employed by the state. While parents have a right to go to due process without an attorney, I do not recommend it. It's just too complicated, very legalistic, very stressful. Even if you have an attorney, it will be stressful. I can guarantee you of that. The district's going to have an attorney. If you're going to go that far, you should do it too. Keep in mind that the statute of limitations for due process hearing is 1 year. In other words, you can't go back 3, 4, 5 years and say they've been doing this forever. You can do that factually, but in terms of a decision of the judge, they're only going to look back 1 year. You're supposed to get a decision under Wisconsin law in 45 days from the date you requested the hearing. However, and by the way, this law has been there for a long time, and it used to take sometimes well over a year, but a long time ago, I sued DPI over that because it was ridiculous. Parents would win a case, but so much time had passed, it was almost like irrelevant. Child's education is suffering all this time. So now it still usually does take more than 45 days, but the parties have to consent. And they usually do for short periods just for scheduling purposes. We have to get everybody on board in the same place. Now, I will tell you, COVID has made this more complicated too. I have not yet had any Zoom hearings, but I believe that's the way they're going to be doing them, at least until the pandemic is over. Now, when I mentioned having an attorney at the due process, that of course is expensive unless you are able to get a free attorney, for example, through Disability Rights Wisconsin, but their ability to do that is very limited. I think they take very few cases a year. I used to work there, but it's been about 8 years since I was there. So if you win or get a very good settlement, you can get your attorney's fees reimbursed by the school district. And the point I have on this slide, where to be a little cautious, especially if you go on your own, if you were found to have filed a due process hearing frivolously, then you could be forced to pay for the school district's attorney's fees. Now, I have yet to see that happen in Wisconsin, but it's not like we don't want to pay attention to that, because that could be very expensive. I've mentioned mediation. I don't think I need to go over this further. Now we're getting to what everybody's been waiting for, the COVID situation. The first thing for you to understand, and the most important reason why I went through all the stuff up until now for the past little over half an hour, is the law has not changed, period. And Betsy DeVos, whatever you may think of her as our Secretary of Department of Education, she made it very clear to Congress that she's not even recommending waiving the law during COVID. I'm not going to pull it up, but there is a hot link there when you get the presentation, and you can look at that article yourself. So the law is the same. It hasn't changed, period. And if school districts start telling you it's changed, they're wrong. It's just not a correct statement. Now, let's face it, the situation has changed, so we don't want to ignore it. And there has been some federal guidance. If the school district closes its schools, as many did in March, and they don't provide any services to any students, then the district, for that temporary period of time, and there was in most school districts, in most cases it wasn't longer than a few weeks at the most, during that period of time, districts were not required to provide special education services and implement the IEP. However, once school resumes, they must make every effort to implement the IEP. Now, make every effort to implement the IEP. And I bet every one of you is scratching their heads thinking one of two things. Either my school district did a bang up job doing all that they could, but all that they could still did not mean face-to-face, one-on-one physical therapy or whatever other services that your child needed. And you could read your IEP back and forth, or your child's IEP back and forth, and say, this was not completely implemented. And you would be right. So what do we do with that? I had a conversation a few months ago with a school district attorney, one who represents many school districts in the state, and she said that she was advising her clients, school districts, to get ready to be providing a lot of compensatory education. Now, for some reason, I don't know why, DPI uses this term that is nowhere found in the law called additional services. They mean the same thing. And what this is a concept that was there even before COVID, but it's become more important. Before COVID, what it meant is if your child, let's say the physical therapist, I don't know why I'm stuck on physical therapy today, but we'll just stick with that. Your child's supposed to get 3 days a week of physical therapy, 30 minutes a day, but then you're in a small district, the physical therapist has a baby and goes on maternity leave, and the district has a hard time finding a replacement. Your child doesn't get physical therapy for 2 months while she's on leave. Well, your child is entitled to compensatory education to make up for that missing service. It can happen in other ways, but that's an easy example. You can also get creative, because one of the problems with compensatory education is there's only so much education we can shove down our children's throats. And if they're in full-time school, adding more school to their full-time school could be very difficult. So that's when we start looking at summertime, other vacations, and then even some creative. I've gotten summer camps paid for in compensatory education. I've gotten computers provided and software, so we can be creative with that. Now, during COVID-19, the plain reality is, even if school districts have done their best, sometimes school districts have not done their best, the child simply is not having their IEP implemented and they are not receiving a free, appropriate public education. So as soon as possible, the discussion should turn to, okay, how are we going to compensate your children for what they missed? Now, the reality for some of them, and I say this with some heartbreak, is depending on the type of services, it may honestly have to wait until the pandemic is over, because face-to-face services are going to be very difficult to keep your children safe. But if it's not that way, and I'll give you an example. I had one client whose school district was providing virtual learning services, but said, we can't do that for speech therapy. And the parent was like, why not? Speech therapy would be pretty easy to provide. It's not hands-on virtually. And they made up some, frankly, BS about HIPAA, which is the Medical Privacy Act around health records. So this mom was, a very good advocate, and she did a little investigation and found out that the school's speech therapist was providing Zoom speech therapy through a hospital to, private patients. So that was ridiculous. They should have been providing it, and they would have to compensate for not providing that. Distance and virtual learning obviously can be provided. This is more guidance. And that problem, of course, is going to be twofold. And there's probably more than two. But one, does the child have access to the technology? Now, many school districts, as you probably know, are providing, Chromebooks and hotspots and all that stuff, which is great if they work and function well. But two, in many family situations, let's say you have 6 children, and let's say you got to go to work. Keeping an eye on all these children, even if the school district gave you 6 different Chromebooks, may be next to impossible. So that may not work for everybody. Gotta get the next slide here. There we go. So I provided you with a couple of links here that have a lot of Q&As. I'm not going to go through all of them. I've given you the highlights from March and from June. The June is about dispute resolution and what to do about that during COVID. But all those tools I told you about are still in play. Now, Wisconsin has already also given guidance. So some is just very practical. So those signatures we talked about on consents, that can be done electronically. That's perfectly fine. Again, assuming you have the technology. If you don't, you need to tell the district that, and they're going to have to snail mail it. That might slow things down, but you can do it that way, or somebody could drop it off at your house. They could also delay graduations. Now, this is an important piece I didn't talk about before. Even under normal situations, students with disabilities may receive up to 3 additional years of public education up till and through the year they turn 21 if they did not graduate and or have other IEP goals that they have not met. Now, typically, that is for more severely disabled children. But this is a tool that you could be using during COVID also to say, you know what, last year was my child's senior year, maybe even this year, and there's no way that they were getting FAPE, and there's no way, even if the school district is lenient and decides to give my child, credits that I don't think they really earned, I want another year of education for my child. And that ultimately is an IEP team decision, but if they disagree, you have appeal rights, and is something worth thinking about. go to the next slide. There we go. Now, the writing of the IEPs, I mentioned the I-10 before, notice of changes, but remember, the parent has to agree, and it has to be just during duration. If the idea is to do it because schools are closed, just for that period, okay? Now, if new IEPs are being written, they may be, although they can be written for up to a year, one thing to consider is writing shorter IEPs. So for example, in Madison and some other school districts, they've decided that schools are going to start virtually for the first quarter this year. You may only want to write an IEP for that first quarter because it might look very different than when schools are back in session. So that's worth considering. What about holding IEPs meetings? Many of them are being done by Zoom, but some parents may not be comfortable doing this. Parents can say no to that. Problem is, especially as this pandemic goes on, how long can they say no? I can tell you what you can't do as a parent. You can't say, I refuse to meet on Zoom, and it's not safe to meet in person. But I'm also going to complain that the school district hasn't updated my child's IEP that's over a year long. I mean, you can do it, but I don't think DPI is going to be sympathetic. So in some cases, you may have to make a tough choice. Even if Zoom isn't comfortable to you, you may ultimately have to try it. Maybe it's getting an advocate to be with you or some other assistance. Remember this, whether it's during COVID or not, a parent always has the right to stop an IEP meeting and to say, we need to continue this at another time. So if you're trying to do it on Zoom and you're just finding, I can't pay attention, there's too many faces and I don't know who's talking and all that stuff, you could say, you know what? Yes, I said I would try to do it this way, but this isn't working anymore, so we need to continue in some other manner. Get to the next slide, come on. There we go. Progress reports. This may be one of the most important things that needs to be done during this COVID period. As I mentioned before, school districts always have to do progress reports on your child. But measuring your child's progress has become more difficult if teachers aren't literally seeing your children. Nevertheless, they still have to do it. So whether that's by telephone, electronically, talking to you, the parent, etc. Now, some parents have a better ability to report on their child's progress. Maybe they can work from home, maybe they don't work at all, maybe they don't have 6 children, maybe they only have 1 or only 1 with an IEP. So different parents are going to have different ability to report. But if you want to advocate for your child, I'm going to show you a couple of kind of self-reporting forms in a few slides that I think you'll find very helpful. If hours of instructions are reduced, then we have this situation about whether or not the child is going to be entitled to compensatory education, or whether or not the IEP can be met, and possibly whether or not it needs to be revised. But again, that can't simply be unilaterally decided by the school district. That's an IEP team decision. So I've got a couple of links here. Now, the first one here is extended school closure due to COVID-19. That came out in May. This next one is came out in June. It is, I wrote an article that was highly critical of this education forward. It is 87 pages long with 87 pages of suggestions to school districts. I've had school districts and school district attorneys complain about this because what school districts wanted and what parents wanted was clear direction. Unfortunately, DPI didn't provide it. If you do open this, special ed is specifically discussed at pages 65 to 70. But again, it's just going to be a menu of options. So I'm not going to go through those menus of options with you because I'm not the educator here. but it is available to you. So where it might be useful is if your school district says, well, I have no options here, or we have no options here, you can certainly look at this as what I would call a smorgasbord of options that you might think, but it's also not the be all and end all of options. There may be other options that you find elsewhere. Now, here's where the tracking of progress and regression is very important. Like I said, some students may need compensatory additional services after this is all over. IEP teams will decide this on a case-by-case basis. The answer will depend on the services your child did or did not get during remote learning and how much backsliding or regression your child experienced. You can help this by monitoring this, okay? And this is a really high priority. So I'm going to show you two forms. One is from the Legal Counsel for Health. It's a daily journal. Let's go there. Okay. And this, again, this is a sample and you can use it. It's not copyrighted, where you literally track how many hours with the special ed teacher, general ed teacher, classroom homework, how many hours you spent assisting your child. Today, your child's work was or was not modified. Lessons today included, et cetera, et cetera. Related services that's in your child's IEP, okay? This is really good. Now, this is just an example. This isn't to fill in the blank. You would have to kind of recreate this for yourself. Now, let me go back here. Hold on a second. I gotta get, oh, come on. There we go. Okay, it's loading up. I'm gonna go now to this one. This one is actually a fillable form by the Southern Poverty Law Center, and it's a school services tracker, okay? It gives you some instructions. I'm not going to go through all of that, but here you can literally see those purple or lavender. You can fill this out yourself, and this is just an example on the top line, but now you can fill out date, type, time spent, description. So one thing that I've suggested to people is to take that first form here and the ideas that are in here, and then use this form that you can fill out, and you can go on for as many pages as you want. Okay, so hopefully that will be helpful to you. Yeah, let's get back to full screen. Come on. Bear with me here. There we go. Back to present. All right. Now, there's also a couple of toolkits. There we go. The National Center for Learning Disabilities is putting out some great information. You can go to their website, which is ncld.org, for all, I mean, scroll around. Do not be concerned if your child does not have a learning disability and they have some other disability, that this won't be for you. This has really been a lot of great resources. I'm just going to show you. So here's an advocacy toolkit. And again, this is learning and attention issues, but it talks about all kinds of things: parental rights, equitable funding, meeting the needs of the whole child, improving. Here you will get some educational ideas, things that are beyond my expertise, assessing and accelerating, just some great, great stuff. Now I'm going to go back so I can get you that other link and show you another really good thing, because one of the things that has come up more recently is, what about the issue of student privacy? Okay, student privacy is a challenge in virtual learning because you got, how do you deliver special education services, which is supposed to be somewhat confidential? Come on, screen. And computer is being, let's see if we can do this. There we go. Boom. So this is, oh no, wrong one. Excuse me, sorry. I was on the wrong page. I apologize. Bonnie said, I've been doing this for 34 years. The truth is it's 35. And if you could see all my gray hair, you would know why I'm not quite as adept as I'd like to be at this technology. Doing pretty good, but please bear with me. Here we go. We want the next slide. So here's the privacy piece. Now it says an educator's guide, and some of you on the line or on the webinar may be educators, but I think this is helpful for parents also. Because it's going to address, you can download the whole guide, talks about federal privacy laws, including both health. And by the way, I wanted to show you this too. So there are a variety of other reports from the National Center for Learning Disabilities that you may find helpful too. So we're getting close to 1 o'clock, so I'm not gonna, I don't have time to go through all of those. And Bonnie, as I'm getting towards the end, why don't you take a look at the questions that people submitted in advance, because we're getting pretty close to question time.
Sure. So are you ready for a couple?
Not quite. Hold on, we're almost there. Yeah, I just wanted to show this screen. So this is my contact information. I also do a blog, which includes my highly critical piece on Education Forward. Feel free to look there. There's my website, email, and phone number. Okay, Bonnie, I am now ready for questions.
Okay, so here's one right off the bat. Does all of what you've talked about today apply to 504 plans as well?
That's a very good question. The truth is, I have seen no guidance coming out. I'm not surprised to see no guidance coming out from the state, because 504 doesn't have an equivalent state law. So DPI always says, well, you'll have to ask the federal government. So I haven't seen specific guidance. I want to be cautious about saying, does all of what I say? The answer to that is no, because they're two different laws. And I've been talking about the IDEA. However, what is definitely true is that 504 has not been waived for children who do not qualify for special education but still need accommodations or modifications based on Section 504 of the Rehabilitation Act. Those plans still need to be made and implemented, and maybe and probably do need to be modified based on a period of time where we're in distance or virtual learning. Next question, Bonnie.
Can families get reimbursed for obtaining care elsewhere if it's not being provided by the school?
All right, that's an excellent question. So first, let's talk about the general state of the law. The answer to that, by the way, is yes. That's a short answer. But let's talk about the general state of the law prior to COVID-19. If a school district does not provide FAPE to your child, the parent has a right to seek and obtain private services up to and including private residential schooling, and then seek reimbursement from the school district. Now, you may have to go to a hearing for that, excuse me, but you had that right even before COVID-19. Now, let's take that speech therapy example I gave you before. Let's say the school district's doing reasonably well during COVID-19, but they keep insisting we can't give your child speech therapy over Zoom. And you found that the exact same speech therapist is doing that through the hospital. Well, I think the appropriate response is, well, okay, school district, if you insist on that, since it's my child's IEP, I'm going to arrange to have the same exact therapist do it through the hospital, and I'm going to have them send you the bill. Now, again, they may object, which might mean you have to go to due process, but I think that's a pretty easy one to win.
Okay, another one here for you. Can children with IEPs who are not able to wear a mask still be able to attend in-person school if the in-person school is being provided?
That's a really, really good question. The short answer is, if the school district is has decided that it's already going to take what I personally think, and I'm not a doctor, but I personally think is a significant risk by having in-person schooling, then and even if the school district mandates masks, you can answer this question for yourself. How many of you think, regardless of disability, that every 5-year-old is going to keep their mask on all the time? I think the answer is probably all of you think that no 5-year-old will keep their mask on all the time, including over their nose. So the reason why I mention that is because the law around reasonable accommodations, and now we're in ADA and 504 territory, okay, this isn't just special education, would look at a situation like that and say, is it reasonable to accommodate a child with disabilities by saying, listen, this child's going to tug at their mask, or maybe they have a skin issue or whatever sensory disorder that they can't wear a mask. It would be a reasonable accommodation to allow them not to wear a mask, because guess what? There's going to be a bunch of kids who are taking their masks off all day long anyway. So I think the answer to that is yes. Now, I want to add one other thing, and I was just talking to a young friend of mine who works with, she's a job coach for people who are deaf. Well, there are also masks that are clear around the lips, because without that, people who are deaf and maybe some other disabilities that can't read lips, it becomes difficult, if not impossible, to communicate. So that might be another accommodation. Maybe you haven't been able to get a mask for your child that has a clear window. So you could say to the district, call it assistive technology, call it whatever you want. Listen, if my child's going to wear a mask, the only way they're going to understand what's going on and you're going to understand them is if you get them one with a window, and I haven't been able to find one. So get my child one as part of their educational program. Next question.
Yeah. And that next question is, as a parent, is there a way that I, as the parent of a child with special needs, be compensated specifically for the fact that I'm going to have to teach my child with disabilities because a teacher and information and lessons were not provided?
That's a very good question. The answer is possibly. Okay. So, in general, I want to revisit the acronym FAPE. The first letter in FAPE is free. The law is very clear that school districts cannot obligate parents to provide educational services to their children, because otherwise that's not free. The typical example we see during normal times is, let's say your child has some behavioral challenges and just has not been able to ride any kind of school bus, even if it's specialized, even if there's supports. And so ultimately the IP team decides and you agree that you will transport your child to school. Upon request, the school district needs to pay you for that, because you taking your child to school is not free. It takes you time, it costs you money. Now, they're not going to pay you a lot. They're required to pay you the same mileage reimbursement that they pay staff for driving their own cars. Now, let's go to this situation during COVID-19. There's no question in my mind that many parents are providing a lot of the educational services to their children during this time that teachers either won't or can't. Excuse me. Let me take a drink. Getting a little dry here. So the tough call here will be to distinguish between what I would call the normal parental assistance that many parents do, helping their child with their homework, for example, that is considered voluntary and not required, versus if I don't do this kind of lesson for my child will not receive the type of free appropriate public education meeting challenging objectives like the Supreme Court said in Andrew F. Okay? And if that's the case, I think you can. Now, there'll be some questions about, well, what's going to be your rate? Okay? Are you trained as a teacher? Your rate might be higher than if you're just doing the best you can as an untrained parent, in which case you might get paid, or at least make a request to get paid, like a special education aide. These questions, I should say, have not yet been litigated. I cannot point you to a case that says, oh, there have been 1, 2, 3, 4, 5 courts that have said yes or no to that question. But I think it is worth pursuing.
Okay, another one that's a little bit different for you.
Sure.
My child has an ISP in a school district. What does this work, or how does it work for my child who goes to this a private school and is getting like PT once a week?
Okay, so if your child is going to private school and is still getting services from the public school like that, then they ought to be, the law hasn't changed. They ought to still be able to get those services. Now, again, we're in COVID-19, so you would ask the school district, how are you delivering physical therapy? What are other students getting? It shouldn't change for you because your child is going to private school. So you're going to have the same challenges as everybody else, but your rights to those services have not changed.
Okay, and we have a couple of others here. What is your advice if you are in a school district who did a unilateral reduction across the district? For example, if there's in speech therapy during COVID-19, it was shared that it is not legal to do so. But what do you suggest in this particular situation?
I suggest that A, you document it, and B, you hopefully have been able to monitor your child's progress for or lack thereof due to the missing speech therapy, and then make a claim for compensatory services to make up for that loss. Hopefully, just upon making that request, the school district will have an IEP meeting. This is what DPI is telling them to do, and agree that, okay, we have to provide compensatory services. If they don't, then you have legal rights to try to resolve that, whether it's through complaint or mediation or due process.
Okay, another question. Should an IEP have been revamped when schools actually closed in March? And what happens if it was not?
I think they should have been, but of course, the problem was we were literally talking about over 100,000 IEPs across the state. And as a practical matter, that became very, very difficult. What really should have been done is instead of sending I-10s, these mid-year change forms that simply told parents what was done, they should have had meetings to, even if it wasn't immediately, at some point, because, okay, March is one thing, but we still had April, May, beginning of June to say, okay, folks, we reacted as quickly as we could. Now we've got some time. Let's sit down and talk about how to revise these things. Now it's fall, or well, almost fall. School's about to start. If they still haven't done that, and you're still operating on the IEP that was written as if your child was going to be going to school physically, or you're operating on what I consider to be an illegal I-10 that was sent just telling you how it was going to be changed, I would put a written request in for an IEP meeting saying, we need to revise my child's IEP. If school's not open, what happened in the spring was not acceptable. You didn't implement my child's IEP. So let's sit down and A, revise the IEP, and B, talk about compensatory education for what my child did not receive earlier.
Okay, so this will give you an opportunity to talk about this question. And this question says, will this presentation be in Spanish?
Yes, indeed, actually. Thanks to Facets, we're working on it right now. Let me see. I don't have the date. I think it's April 25th, which actually, Bonnie, you asked me before. I'm also doing a presentation to the State Bar for lawyers, and it's actually that same day.
Okay, not April, you mean August.
I meant August. Thank you very much. Sorry.
Yeah.
I'm pretty sure it's August 25th, and I think it's going to start at 3. Facets will be getting information out about that, the Spanish language one, and we're going to translate all these slides. They're in the process. Facet staff is working on that into Spanish, and they're going to have, I will still be doing the presentation, and although I speak a little Spanish, it's not enough to do this fluently in Spanish. We will have a live interpreter. So whether, maybe some of you would like that, or if you know Spanish language speaking families who really could use this information, make them aware of this. I assume, Bonnie, that Facets will be sending all of these people updates in terms of new webinars that they might be interested in. That will be included in there. So keep an eye open for that.
Yes, we'll be doing that. So yeah, thank you for that. We have a couple of more questions before we have to sign off, and I'll try and get as many in as I possibly can. Are public and private voucher schools held to the same standard since Betsy DeVos is holding public schools accountable to these standards?
I want to distinguish, I have to be careful around the public versus private voucher. Okay, there isn't really such a thing as a public voucher. There is open enrollment, which would be going to a different school district. That's a state law. There's also public charter schools, which are absolutely held to all the same standards that we've just discussed. They may or may not always follow them, but the IDEA applies in public charter schools. Private voucher schools are, even if you have under Wisconsin law one of these special education vouchers, were not before and are not now obligated to implement IEPs, follow the IDEA in any way, shape, or form.
Okay, and another quick question, and I think it probably leads to the discussion about what's been happening between schools and the trust issue. Can conversations between the parent and the school district be recorded?
That's a good question, and that applies regardless of the COVID, although there may be more reasons since, like Zoom, for example, has a record button and you could just record. Although if the school district's the host, they'll be in control of that. Under Wisconsin law, you're allowed to record. However, if anybody objects to the recording, then you're not supposed to record. What I recommend in those circumstances, if there's an objection, is that you ask for it as an accommodation. So if you need the recording because maybe you as a parent have ADHD or some other disability that requires you to be able to go back and listen and pay attention to what happened, I would make the request as an accommodation. And then it's not your child's accommodation, it's your accommodation. The school district should grant that. Now on Zoom, since the meeting could be recorded, and if that's what you want, I would make that request, but then it's going to be important on the school district's part to make sure that that recording stays confidential and doesn't just get leaked out, because that was absolutely a confidential meeting.
Okay, and another question real quick. Who has the responsibility of providing the parents with access to technology, specifically internet?
That would be the school district. The school district is obligated to provide your child with an education. If school is closed and they're providing school through the internet, then the school needs to provide that. Now, there might be some arguments about whether that legal requirement is in place for non-special education students, although I would believe that it is, because in Wisconsin and in every other state, there is a state constitutional right to a free public education. And if the school building's closed and the only way to get it is through online, then the school district has to provide it. That being said, for sure for special education, because if you can't deliver the education, which includes the parent and the child's ability to receive it, then the child's FAPE has been denied. Now, I will add this, and this is where I think the trickiest situation is. For those of you who may be in rural parts of the state, where even if the school district gives you a Chromebook, and even if they give you a mobile hotspot, your internet connection is so poor that it doesn't stream well, because Zoom takes a lot of gigabytes, to stream well. Then you're going to have a conversation with the school district. It might mean that you have to go somewhere. I don't know where, maybe to a public library, but I know most of those aren't open. I've seen situations where people, I don't like this, but it may be what has to be done. Go to the library and are accessing the school district's, the public school's Wi-Fi from the parking lot. And of course, in the winter, that's going to be very, very difficult. And keeping any child in the car, or if you have multiple children, is going to be pretty untenable. But I would work with the school district in those situations to try to come up with the best possible solution, even though it may not be ideal. But it is the school district's obligation to provide that.
We have multiple other questions, and I know we have no time left. So I want to let everybody know that we had over 300 people that were on this webinar and that we aren't able to get to everybody's questions. So I hope that you'll all understand that, and that hopefully a lot of your questions were answered during the course of Jeff's presentation today. At this time, Jeff, do you have a closing statement for us?
I just want to mention that Bonnie and I talked about, and this isn't, I don't mean to put facets on the spot, but because there's so many questions and I know there's so many people on the line, we may see if we can come up with a session that is simply a Q&A, because we know there's lots of questions. It might not be just me. Maybe we'll have a small panel, which might include some educators that can give you some education ideas. Other than that, I know this is a difficult time. I empathize with all of you. There's no easy solutions to this. Nobody in the world has lived through what we're living through, because we haven't had a pandemic since the Spanish flu in 1918. And if anybody is over 102 years old, they were teeny tiny babies at that time, and I'm sure they don't remember it. So, take care of each other, stay safe, keep your families healthy, and I wish you all the best.
Thank you so very much, Jeff. We really appreciate your presentation today and your expertise. I know that I learned a tremendous amount, and I'm sure that all of you who are participating today has as well. Just to reiterate the fact that all of you who signed up, whether or not you were able to attend the live presentation or not, will be receiving an electronic copy of the webinar. So you'll have it to be able to replay or to share with others. At this time, again, thank you, Jeff. This will conclude our webinar. We'd like to thank everybody for joining us today. Please be reminded that Wisconsin Facets has over 80 scheduled trainings and webinars for the year 2020. Please feel free to check out our website calendar and register for any of our upcoming trainings. And please watch for the short evaluation that will be coming your way after the conclusion of our webinar today. Thank you, Jeff, again, and everybody, thank you for your attendance. Have a wonderful rest of your day. Bye-bye now.
Bye.